Hi, welcome to our channel of IGNOU audiobooks. Indira Gandhi National Open University, School of Social Work, SOSW, Certificate Programs, Certificate in Social Work and Criminal Justice System, CSWCJS, MSW-032 Social Work and Criminal Justice, Block 1 Introduction to Criminal Justice, Unit-1 Concept of Deviance and Crime. 1.0 Objectives. By the end of this unit, you will be able to understand the meaning of deviance and crime, explore the various typologies and patterns of crime, and enlist the function of deviationism and criminalization. 1.1 Introduction. The concept of deviance and crime are central to the understanding of criminal justice in any society. All societies that are constituted by the individual members, men and women, lay down certain ground rules for guiding and regulating the freedoms of thought and actions of its members. Thus, a liberal and permissive society may accord to its members greater freedom, whereas a conservative and authoritarian society may concede limited freedom to its members in matters of thought and action. As a consequence, human behavior and action is routinely labeled as deviant, or a kind of deviation from the expected or normal behavioral standards. What constitutes deviation is in turn influenced by the nature of the society, primitive, traditional or modern, stages of its development. Underdeveloped, developing or developed, evolution of systems for dealing with deviations and regressiveness and progressiveness of its outlook, etc. Crime constitutes a distinct kind of deviation that is backed by the dominant political power that has far-reaching consequences, like serious stigmatization, formal prosecution and punishment, etc. This makes deviance and crime a multifaceted and multi-issue inquiry. The foregoing pages are devoted to an issue-wise discussion of the core theme with a view to giving to the readers a comprehensive understanding of the complex and interdisciplinary theme. 1.2 Deviance and Crime. Sociologists define human behavior in terms of infraction of some agreed-upon rule. Thus, according to Cohen, 1966, deviant behavior is behavior which violates institutionalized expectations, that is, expectations which are shared and recognized as legitimate within a social system. The same normative conceptualization is followed by Clinard, 1963, who describes deviant behavior as behavior in a disapproved direction from the norms and sufficient in degree to exceed the tolerance limit of the community. p. 22. Sociologists, whose main concern is to capture the social reality as closely as possible, remain preoccupied with an analysis of institutionalized expectations of normative standards of the community, which tends to bring an element of non-criticality in their approach. Unlike this is the lawyer's concern with crime, a special form of deviation has been subjected to much greater analysis that is reflected in the wideness of crime discourse itself. The distinctively of crime type. Deviation lies in a. Involvement in acts or omissions which are prescribed by law, and b. Infraction of norm entailed by imposition of penal sanction or punishment. Thus, involvement in crime leads triggering a set of consequences, ultimately leading to imposition of punishment. An authority on criminal law, IGNOU, outlines of criminal law, identifies the following three characteristics of crime. 1. That it is a harm brought about by human conduct which the sovereign power in the state desires to prevent. 2. That among the measures of prevention selected is the threat of punishment. 3. That legal proceedings of a special kind are employed to determine the guilt of the accused before being punished. This way both the sociologists' and lawyers' conception of deviance and crime have two common features. First, both treat institutionalized expectations of community norms and law as a good thing, or a desirable social entity that is assumed for the larger happiness of the society. However, while emphasizing the fact of normative fidelity, one has to be aware of emerging, though held by a few, trend of those who perceive norms or law neutrally as a set of power resource that can be used for bad or repressive purposes as well. Second, deviance and crime are premised on an implicit subscription to a consensus model in regard to harmful behavior. The consensus model constitutes the strongest basis for legitimization of the criminal justice systems in the modern societies. However, the consensus view is also critiqued by a few who subscribe to a conflict model that views deviance and crime in terms of conflictual relations between the dominant and subservient sections in the society. The conflict view is best reflected in the ideas of left-wing sociologists and criminologists such as Chambliss, 1975, Richard Queenie, etc. David Mapsa, 1969, provides a reconciliation between consensus and conflict models by suggesting a dynamic frame for conceptualizing deviance. He conceives deviance in terms of the problematic empirical complexity of the society, for there inevitably exists, particularly in industrial societies, not one commonly shared and consensually agreed to culture, but plurality of cultures, which do not coexist without considerable tensions and conflict. The competing cultural entities constantly strive to legalize and transform their cultures into dominant culture. But despite legalization of culture, legitimization may still be lacking and non-dominant cultural groups may continue to follow their own cultural practices and standards. This makes the issue of legitimization a source of constant tension, because some groups press for their cultural practices to be recognized by law and turned into crimes, while as other cultural groups press for abolition from the legal code. Certain behavior patterns, thereby to resort to be decriminalization. Technical connotations of crime and their essential components under substantive and procedural laws. Under the codified criminal law system, crime means an act punishable by the Indian Penal Code 1860 or other penal statutes. We shall now endeavor to explain the elementary ideas involved in the concept of crime and its peculiarities that distinguish it from other civil wrongs. Austin distinguishes civil injury from crimes in terms of the party that initiates action and has the discretion in the matter. In civil injury, the injured party has the privilege and discretion to pursue action, while as in crimes the action against wrongs is pursued by the sovereign or his subordinates. According to Blackstone, crimes are public wrongs that affect the whole community. But in fact, public and private wrongs are not exclusive of one another. In civil wrongs, the normative transgressions are visited by restitutive compensation to the victim party. But in cases of crimes, punishment alone is considered as the adequate restoration of transgressions. In these cases, full restitution to the wronged individual and to the society is often impossible, and the law, instead of proceeding on remedial lines, punishes the offender partly as a measure of prevention and partly out of retribution. Punishment, however, to be effective as a measure of Prevention deals with deliberate acts directed by an evil mind and thereby aims at eradication of evil will. Therefore, crimes are comparatively graver wrongs than civil injuries. They are graver because they constitute greater interference with the happiness of others and affect the well-being not only of a particular individual but of the whole community. They are graver because the impulse to commit them is often very strong, nor because the advantage to be gained by the wrongful act and the facility with which it can be accomplished are often great. They are also grave because they are ordinarily deliberate act directed by an evil mind and hurtful to society by the bad example they set. Thus, crime is an act done with malice or criminal intent. This is called the condition of criminality or the state of imputability, which may include both positive and negative states of mind such as intention, knowledge, likelihood, rashness or heedlessness, and even negligence. 1.3 Essential elements of crime. After understanding the exclusion of many forms of injuries from the ambit of crime, it may be useful to identify the peculiarities of crimes in terms of its basic elements such as a willed human action that results in evil consequences that is known as a serious element. B. Guilty mind on the part of the wrongdoer to indulge in a prescribed act or omission leading to harmful consequence to an individual or to the society. That is known as mens rea element. C. Requirement of prohibited act being done with the prescribed guilty mind. That is known as the concurrence element. 1.4 Crime, offense and its variants. The Penal Code and the Code of Criminal Procedure, 1973 have used the term offense instead of crime. The rationale for such a change of terms is that, first, crime is a generic term and offense relates to specific prescribed conduct covered by each offense, and second, establishment of the elemental requirement of a specific offense leads to justifications for imposing the prescribed punishment. Section 40 of the Indian Penal Code lays down, except in the chapters and sections mentioned in clauses 2 and 3 of this section, the word offense denotes a thing made punishable by this code. In a similar vein, Section 2(n) of the Code of Criminal Procedure lays down, offense means an act or omission made punishable by any law for the time being in force and includes any act in respect of which a complaint may be made under Section 20 of the Cattle Trespass Act, 1871. The Criminal Procedure Code further classifies offenses for the purposes of different criminal justice processes as follows. A. For the purposes of arrest and investigation, cognizable offense, S. 2. C. Cr. PC, and non-cognizable offense, S. 2. B. CRPC. Cognizable offense are generally more serious offenses as per the first schedule of the CRPC. In view of their seriousness, the code provides for distinct first information, investigation and arrest procedure in regard to them. Non-cognizable offenses are less serious and therefore investigation and arrest in regard to them requires a direction from the appropriate judicial authority. B. For the purposes of bail. Bailable offense and non-bailable offense, S. 2. 8. Like cognizable offense and non-cognizable offense, use the categorization conveying the seriousness of the offense in terms of the scheme of the first schedule of the code. In bailable offense, bail is a matter of right, but in cases of non-bailable offense, it is a matter of judicial discretion. C. For the purposes of compounding proceedings. Section 320 of the Code provides an elaborate scheme for the compoundable offense, which are treated more like civil wrongs that can be compromised with the permission of the court. D. For the purposes of plea bargaining and sentencing. Though the code does not explicitly use the terms petty offense and serious offense, but there are several provisions in the code which implicitly categorize offenses into two categories, namely, A. Offenses punishable with less than 7 years imprisonment, and B. Those that are punishable with more than 7 years imprisonment. Such a classification is relevant for the purposes of claiming plea bargaining, S. 365A, and reformative sentencing, S. 360 in the Probation of Offenders Act, 1958, benefits, typologies and patterns of crime. Deviance and crime are broad categorizations to demarcate the right from wrong or normal from substandard behavior at a macro level, but within these broad categorization are subsumed a wide range and diverse types of specific deviant behaviors, which are described as specific crimes or offenses by diverse criminal statutes. The principal criminal code in India is the Indian Penal Code 1860 that serves as an omnibus code for different categories of offenses. The Penal Code provides for offenses grouped into 22 clusters classified on the basis of invasion of a cherished social interest that are titled as offenses against the state, offenses relating to Army, Navy and Air Force, offenses against the public tranquility, offenses by and relating to public servants, offenses relating to elections, contempt of lawful authority of public servants, false evidence and offenses against public justice, offenses relating to weight and measures, offenses affecting public health, safety, convenience, decency and morals, offenses relating to religion, offenses affecting the human body, offenses against property, offenses relating to documents and property marks, offenses relating to marriage, defamation, criminal intimidation, insult and annoyance, abetment, conspiracy, and attempt to commit offense. Within these broad clusters are grouped individual offenses that are directed to protect a particular type of interest. For example, offenses affecting the human body, ch. 12 Penal Code, envisages 8 diverse ways of invasion of human interest, such as affecting human life, causing miscarriage, etc., causing hurt, wrongful restraint and confinement, using criminal force and assault, kidnapping, abduction, and forced labor, sexual offenses and unnatural offenses. These 8 subheads comprise individual offenses like murder, culpable homicide causing death by rash and negligent act, etc. At the operational level, the lawyer has to be concerned with each specific offense or the smallest denominator of deviance. Apart from the penal code, there are several other special and local criminal law statutes for dealing with prescribed behavior on the basis of special interest group like the SC or SENT, women and children, etc. Also, at times, special crimes are created for the protection of vital economic interests of the society. There are also some special category of strict liability statutes that create crimes which do not require explicit proof of guilty. Main element for the creation of liability. Apart from the traditional crimes, offenses classification provided by the Indian Penal Code and special and local laws are also identified by non-traditional labels such as organized crimes, white-collar crimes, privileged class, deviance, cybercrimes, terrorism and extremism, etc. These non-traditional patterns of criminality are posing greater threat to the individual and community interest in the contemporary societies. The incidence of crime is measured through official and non-official statistics about crimes in the society. In India, the National Crime Records Bureau has been coming out with an annual Crime in India report for over 3 decades. Now, the Crime in India categories the individual offence statistics under two broad heads, namely A. IPC crimes and B. Special and local law crimes. The IPC crimes are further subclassified into violent crime, property crime, economic crime, and other miscellaneous crimes. 1.5 Functions of deviationism and criminalization. Social contract thinkers such as Thomas Hobbes had envisaged long back that to get away from the state of nature in which men lived a life that was nasty, short, brutish, solitary and poor, the Leviathan had to enact strict rules of behavior for its members. The same kind of unquestioning faith in rules is reflected in the writings of later thinkers like Beccaria and Jeremy Bentham, for whom behavioral rulemaking became an essential attribute of a good sovereign. Sociologists and researchers on deviance have analyzed the diverse dysfunctions of rulemaking or deviationism and criminalization in the contemporary societies as follows. 1. As a measure of solidarity and stability. Durkheim, in his work Division of Labor in Society, 1893, considered the social integrative abilities of crime in these terms. Crime brings together upright consciences and concentrates them. We have to notice what happens, particularly in a small town, when some moral scandal has been committed. They stop each other on the street, they visit each other, they seek to come together to talk of the event and wax indignant in common. 1947, p. 102. Writing in the same vein, Durkheim, 1938, advocated the idea of normality of crime by showing its presence in every society and by underscoring the functions it performed for the society in these words. Crime, we have shown elsewhere, consists of an act that offends certain very strong collective sentiments. In a society in which criminal acts are no longer committed, the sentiments they offend would have to be found without exception in all individual consciousnesses, and they must be found to exist with the same degree as sentiments contrary to them. Crime is then necessary, it is bound up with the fundamental conditions of all social life, and by that very fact it is useful, because these conditions of which it is a part are themselves indispensable to the normal evolution of morality and law. Like Durkheim, Karl Marx also subscribed to the functionalist view of crime and deviance. But for Marx, crime aroused the pro-capitalist moral and aesthetic sentiments of the public. 2. As a measure of social defense. According to those who subscribe to the views of Hobbes that emphasize the dysfunctions of deviance and crime, individuals who break the law need to be controlled and punished as they threaten the security and stability of the society. There is a whole school of new classicalist or conservative revivalist thinkers who emphasize on a more law and order society. Wilson, 1975, prefers to clearly demarcate between wicked and non-wicked people this way. Some persons will shun crime even if we do nothing to deter them, while others will seek it out even if we do everything to reform them. Wicked people exist. Nothing avails except to set them apart from innocent people. And many people, neither wicked nor innocent, but watchful, dissembling and calculating of their opportunities, ponder a reaction to wickedness as acute of what they might profitably do. We have trifled with the wicked, made sport of the innocent and encouraged the calculators. Justice suffers. And so do we all. pp. 21 to 22. According to those who argue for social defense, the rise of crime beyond historically recorded levels can create a breakdown of community ties and a rise in informal, vigilant-type protective responses which further tear a community apart. This is almost opposite of what Durkheim Marx thought about crime. Such functional measure assumes special significance in the wake of rise in crime of terrorism that demands that the society needs to be protected and secured at any cost, both by stringent anti-terror laws and rigorous implementation of interrogation, arrest and preventive detention measures. 3. As a measure of social ranking and exclusion. Deviance and crime often serve the function of stigmatizing and social exclusion of the lower caste, low-ranked professional groups. During British rule, the labeling of certain tribal population as criminal tribes and depriving them from land and other property rights is a case on point. Garland, 1985, has made the following observation in the context of special section of population for penalty as follows. When we talk of the population of criminals dealt with by penalty, we should not mistake for a diverse amalgam of individuals randomly distributed throughout the general population. Penalty deals, and has always dealt, with a population overwhelmingly drawn from the working classes. Foucault, 1979, has expressed similar function performed by the disciplinary rules within prisons. Alan Norrie, 1993, has rationalized the function performed by prisons this way.
They cannot be deterred, but they can be removed from circulation for a period of time. The prison thereby acts as a cordon sanitaire between the relatively law-abiding and the rest. While containing the one group, it acts as a symbol to the other of the dangers of crossing the line between criminality and respectability. p. 202. Stephen Box, 1983, views the problem population comprising of able-bodied, unemployed and unemployable as those who can create a legitimacy